Discrimination based on sexual orientation is at the cutting edge of civil rights. Prior to 2020, most states did not have laws which prohibited discrimination based on sexual orientation or gender identity. When workplace protections finally arrived, it wasn't through the passage of new laws, but rather the Supreme Court's ruling in Bostock versus Clayton County, which at long last protected LGBTQ+ employees. I'll talk about this ruling and other key issues related to LGBTQ+ discrimination. The Supreme Court ruled that discharges based on sexual orientation or transgender status violates Title VII because it is essentially treating employees differently based on their sex. The court stated it was unimportant to address whether the term sex includes the concept of gender identity, which is each person's internal individual sense of gender, nor does it explicitly mention gender expression, how a person publicly expresses or presents their gender. While the decision appears to be broad enough to protect against discrimination based on these concepts, a fuller exploration of these bases was left to future cases. Currently, some states specifically prohibit discrimination for these reasons, while others do not. Substantiating that an employer knew of your LGBTQ+ status when you applied for a job can be tricky. A transgender person's gender identity might be apparent at an interview, but usually sexual orientation would not. You would need to clearly define what was visually apparent to the interviewer that would communicate your sexual orientation. If you were not interviewed, it is even tougher to establish that the employer knew of your LGBTQ+ status. You would need to identify how the employer learned of your LGBTQ+ status. While this might not be apparent on your application, LGBTQ+ status could be discovered by an employer who views an applicant's social media accounts as part of their application process. More than 2/3 of employers use social media during the hiring process, especially LinkedIn, Facebook, and Twitter. Disparaging comments and jokes are frequently told when members of the group being disparaged are not in attendance. For employees who are not out at work, homophobic comments might be made in their presence on the assumption that they are straight. These employees might be subject to more frequent hostile comments as a result. Harassment because of sexual orientation or transgender status is illegal when it creates a hostile work environment. A hostile work environment is defined by the frequency and severity of the conduct, the perceptions of the victim, and the employer's knowledge of the harassment. As with other types of harassment, management must know of the harassment and fail to take prompt and effective action. A complete explanation of a hostile work environment can be found in the video on sex discrimination. Individuals who actually identify as LGBTQ+ and those who are perceived as being LGBTQ+ receive the same protections against discrimination. In the workplace, your sexual orientation typically cannot be determined unless you divulge this information. A conclusion that you are not straight might be based purely on speculation, stereotype, or rumor. Even so, if you are perceived as such, you may be subjected to as harsh of treatment as LGBTQ+ individuals, even if you are actually straight. Myths, fears, and stereotypes fuel the discriminatory behavior against employees regarded as being LGBTQ+. A fear could be that other people might think gays are sexual predators, and business might suffer if parents do not want their children at a camp where a gay man works. Try to identify the myths, fears, or stereotypes behind the discriminatory decisions to establish the motivation of the decision maker. This strengthens the link between the decision maker's belief that the harmed employee is LGBTQ+ and the adverse action. Creeping tendrils of homophobia may also wrap themselves around those who associate with LGBTQ+ community members. You might be subjected to abuse for various reasons, including that you are friends with LGBTQ+ people, advocate for LGBTQ+ rights, or make laudatory comments about an LGBTQ+ individual. In the past, an employer could establish different dress codes based on gender, as long as it enforced the dress codes consistently for members of both genders. Under this rubric, a person who is transgender must adhere to the dress code of the gender they identify with. The Supreme Court's ruling in Bostock versus Clayton County did not touch on this issue directly, but the reverberations of that decision will be felt in the courts for years to come, particularly on the subject of dress codes. For example, is a dress code that has two sets of rules, one for men, one for women, discriminatory to someone who identifies as gender non-binary? Eventually, the courts may require employers establish gender-neutral dress codes and grooming standards, and limit gender-based dress codes to those positions where there are bona fide occupational qualifications. In the interim, there are state and local laws that have broader protections. These laws are common in large cities and in progressive areas. For example, California prohibits discrimination based on gender expression and gender identity, and discrimination based on gender expression is also prohibited in New York. Now you know all about LGBTQ+ discrimination. If you'd like to learn more about another protected class, like race, jump now to the appropriate video in this series. Otherwise, check out the video which discusses retaliation. You need to know how to be protected when complaining about discrimination. If you found this video helpful, please click the like button. And if you've experienced LGBTQ+ discrimination and have any tips that might be helpful to others, please leave them in the comments below. Thanks for tuning in.